Hello and welcome to another Smaulgld live stream. Tonight is Sunday evening, the 16th of December, 2018. Tonight's topic is JPMorgan going down in flames as law firm moves to create a class action lawsuit, and that is coming on the heels of a guilty plea in a criminal prosecution in a federal case. We're going to talk about that case. We're going to break down the difference between the private cases and the potential consolidation of those cases against JPMorgan for manipulating the precious metals markets, and what the impact of the guilty plea of the JPMorgan former trader has or might have on that lawsuit, and what impact that might have on the metals markets and JPMorgan itself. Before we do that, Smaulgld game changers, let's take a look at the gold and silver markets. Right now, gold is pretty much flat. In the after hours at 12:36, it's down $2. And silver went down a little bit, down a penny to $14.53. Now, the pre-markets for tomorrow, the futures, looks like they're up a little bit, imply an open of about 50 points on the Dow, 4 or 5 points on the S&P, and the NASDAQ up about 15. If that holds, we'll have a moderate open in the morning. Now, over on the cryptocurrencies, let's take a gander. What's going on over there? A bit of a boost today. The big boost came in Litecoin. Litecoin shot up about 12% earlier in the day, and now there's the Litecoin. I gotta find, here it is. Coinbase, not Coinbase. According to Coinbase, Bitcoin is at 32.11. That's up about 0.5%. Bitcoin Cash up only 0.18% at 79.53. Ethereum at 84.22, up 0.85%. But Litecoin up right now 8%. Fell down a little bit. Was up over $26 earlier today. It's at $25.47, and Ethereum Classic $3.62 plus 1.26%. Key here is that Litecoin is now worth more than both of Bitcoin Cash and its fork, but of course trading below its the real Bitcoin. Okay, well, let's take a look at what's going on with JPMorgan. A lot of news here with JPMorgan and its manipulation of the markets, and we're going to go through the history of this. So back in, must have been 2015 or 16, a couple of cases came up, 3 cases actually. Shack versus JPMorgan, Wacker versus JPMorgan, and Grummet versus JPMorgan. And they brought lawsuits very similar, and what they were saying was that JPMorgan was making what's called uneconomic bids. Meaning they would bid and they would lose and it didn't matter. And it didn't make any sense when it would make those bids. And as a result, their clients lost money. And the court said, get out of here. That we don't think that you've made out a case just failing to show uneconomic bids. That's not going to do it for us here. And they're saying, well, they abused their power in the silver futures market. And the judge said, and they were arguing basically on an antitrust claim, that JPMorgan was using its monopoly position in that market to gain a further monopoly in the market. And judge says, sorry, go away. And that was, I think that was in June of 2016, and a lot of people were very disappointed. They said, look, here we go again. They've brought out a case, and they've been told to go pound sand. And that was 2016. They were cleared. However, in February of 2017, the appeals court overruled the dismissal of that silver manipulation case. And they rejected that concept that they had failed to make. They failed to show that JPMorgan made uneconomic bids. And they took on the case of whether JPMorgan was manipulating the price lower to take advantage of a pricing deal with a silver miner. See how devious this can be. Well, the Second Circuit Court of Appeals, remember you've got the District Court and then the Circuit Court and then finally the Supreme Court. This case has reached the Second Circuit Court of Appeals, and back in February 2017, they said that that dismissal was in error. And that, remember, that case was an antitrust case. Now, the reason they bring antitrust cases, they also bring fraud, and they bring them under a lot of cases. A lot of, when you bring a lawsuit, you can bring your case and allege a number of wrongdoings. General fraud, you can breach general fraud, breach of contract, interference with contract. But antitrust is a good one because if you win, you get triple damages pursuant to the statute. So it's not just enough to show that, well, it's enough to show fraud if a party is manipulating on the COMEX and you're damaged by it, you can get your fraud damages, but you want to show if they're a monopoly and you can establish their monopoly, and as a result of that monopoly, they commit fraud or harm you in a fraudulent way, then you're entitled to the treble damages. And as we mentioned, the first case at the district level said no, that JPMorgan, they did not show that JPMorgan made uneconomic bids because they didn't provide details on specific trades or even the names of JPMorgan counterparties with whom the trades were conducted. So under the district court, they said that they did not make even a proper plea. They didn't even get to the merits of the case. They just dismissed it and said that these guys didn't make a sufficient plea that showed that JPMorgan intended to rig the markets at their expense, at the counterparty's expense, or that JPMorgan made these so-called uneconomic bids. Now, the circuit court disagreed. And they said, no, you shouldn't have thrown this out. They gave enough information. They didn't say, we overrule the case and now we're going to award the plaintiffs big money and JPMorgan's in a lot of trouble. They said that the level of detail there was enough, and you shouldn't have thrown the case out and just dismissed it. Charlie, well, his name wasn't Charlie. The lawyer's name was Engelmeyer. But Engelmeyer, you shouldn't have done that. And the appeals court said, look, these guys only need to allege enough facts to raise a right to relief above the speculative level. You don't have to plea each and every case. That's what the purpose of a trial is, to go through each and to litigate each and every fact in the case. This is a procedural issue, not on the merits, but at least the case gets back in front of the court again, because they said they just need to raise enough facts, allege enough facts that rise above the speculative level and that need to state a claim that on its face is plausible. And the circuit court said these guys did that. They didn't say these guys proved their case. They didn't say anything like that. Okay, so at this stage of the proceedings, now it has to, they said they don't have to provide all that specificity now. That's what discovery is for, and so on. And the appeals court noted fact-specific questions cannot be resolved on the pleadings, and objected to what Charlie, or Judge Engelmeyer, said. His conclusion was failure both to explain why SIFO should track silver future spreads and to concretely plead that it did so consistently was engaging in impermissible fact-finding. And then he said, while the district court may well be proven correct at a later stage of this litigation, our precedents cautioned against assessing the choice of a benchmark at the pleading stage. So they decided they had enough specificity to bring their case. It's just that you're not going to resolve those at the pleading case, and the judge shouldn't have tossed the case out at that stage. So the appeals court essentially said that, look, you're under the Sherman Act, the antitrust statute. And you are going to try to make this claim, and you have to allow the plaintiffs to make this claim. Okay. That was back in February. This case is still going on. They're still asking to see documents. They're doing everything that the Judge Engelmeyer at the lower court wanted to prohibit, wanted to avoid having a case at all, throwing it out. But the appeals court said that the district court erred in dismissing the plaintiff's claims, both the state claims they gave them under like New York fraud, federal antitrust laws, and they said it's got to go back now to the court, and people need to, in a sense, relitigate it. Now the problem is, I think it goes back to the same judge who is not very friendly to them, but that case has been going on for a while. Okay, so those are the two cases, the three cases that were thrown out and then revived by the appeals court, and then they've been going back and forth and back and forth. And I think the last I saw of it, they were looking to interview 3 more JPMorgan employees, and JPMorgan was saying, "Oh no, we don't want to allow them to do this." So it's classic, very expensive litigation. I don't have everything that's happened since February 2017, but you got to realize now these guys have been filing this case going way, way back. I mean, it's at least 2015. They got it thrown out. They got it revived. Then they're back and forth interviewing witnesses. Then there's probably delays. Very expensive case here. There's 3 of them. Okay. So everyone figures, well, that's a win, but it's not really a win. It's only they avoided a loss because the case is still ongoing. Fast forward to November of this year, and we have a guilty plea put in on November 6th. We had a release from the Department of Justice. Now remember, those other cases are private cases. They're not criminal cases. They're private suits. And they're saying that JPMorgan done them wrong by creating all these strange bids and using their power to influence the markets to drive money away from their client's position. And one of the problems with that type of case is the business judgment rule. They haven't pled this case, but I could see it coming. The business judgment rule says that courts are not going to get involved in the business judgment as to why a company does what it does. And I had direct experience in a case like this where 2 companies were going to merge, and a third party came in and said, "No, we want to pay more." And the 2 parties said, "No, we don't want to take your higher bid." And then the company said, "We'll double our bid," or whatever. They kept increasing their bids, and the party said, "Go away. We've decided to put this merger together. We spent a year on it, and go away." And they said, "But our bid is superior to the bid you're entertaining in your merger. Why don't you take our bid?" And they said, "Why don't you go away?" And so the third party said, "Well, we're going to sue on behalf of your shareholders. We're going to make the company take our bid because it's superior. Are you guys stupid? Why wouldn't you take more money? Why are you going to merge with those guys? They're paying you 50% less than we're going to pay you." Well, you would think that's a slam dunk. They went to the court, and the 2 parties that originally had merged, they didn't hardly plead anything. All they did was present in a filing all the discussions they had had over the course of the last year, explaining that they had met, that they had discussed the synergies between the 2 companies, and they showed all the documentation that they had reviewed, why they thought the merger made sense, and that was it. And then they said, and according to the business judgment rule, it doesn't matter whether these guys want to pay more. We think, the boards of directors of these companies think that this is a better deal. So that's it. Now, person sitting around saying as a shareholder, like, how is that a better deal? I can get 30% more from these guys over here. But the argument is that the 2 companies had, and the way they showed their business judgment was, They had board meetings. They decided this was a better deal. And because they thought, maybe the stock price would rise past the point of the additional bid that the other party was going to make, that the combined entity would do better as they had discussed for a year than this new third party coming in and trying to break up the party with a higher bid. Maybe that deal might have been a disaster. They hadn't analyzed it as much. So they did analyze the new bid, and they still concluded that they'd rather take less money. Now you would say, well, that's stupid. That is dumb. Why would a board meet, look at two bids and say, well, this one is lower, but we've been talking to these guys for a year, but this one is higher, a lot higher, so why don't we take the lower bid? And the court said, no, you're right. Business judgment rule. We're not going to get into why you might make these decisions. Now, the reason I use that case is it's the same thing. If JPMorgan wants to, in their own business judgment, throw money at stuff, they can throw money at stuff, even if it's uneconomic. Like, why did you make that stupid trade in the middle of the night where you naked shorted a bunch of silver? Looks stupid. But the court's going to say, well, if they have any business reason to do it, which they could, maybe they're giving some training to a trader to show them what happens when you do that. Who knows? As long as they have some plausible business judgment, they're going to uphold it. So you can't just say, well, it looks really fishy here. As long as there's some, even if you think it's uneconomic, maybe it's part of a grander scheme of trading that they do. And it may sound stupid, but that's actually defense. The business judgment rule protects companies, even if they want to make decisions that appear to everybody else as not being sound, not making sense, because the courts don't want to be. And they're not, these are judges. These are people that probably studied history in high school, in college, went to law school, became a judge. They don't know anything about business. Now, something may appear on its face to be simple, but courts, as a matter of restraint, don't get involved in making judgments. Okay. So that case might have had legs, maybe not. That case has not been sorted out, and JPMorgan has not settled it. That case is still ongoing. However, in November of this year, the Department of Justice actually announced a guilty plea against JPMorgan, former JPMorgan trader. And this is guilty in a criminal case. And they didn't come to the antitrust issue. They didn't have any, that wasn't what was at issue. They charged him with commodities fraud and conspiracy to commit wire fraud. And he pled guilty to commodities price manipulation and spoofing. Now, the sentencing for this is scheduled for, check my calendar here, Wednesday. Now, I don't think sentencing is going to impact the case for the private plaintiffs, but this case is going to impact their ability, perhaps. Remember, the private case is a civil case. They're not looking to get JPMorgan arrested. They're looking to extract that fine for fraud, fine for damages that their clients incurred as a result of whatever they're alleging JPMorgan's trading activities were. And they want to get that antitrust. They want to show that, look, they're a monopoly, and they engage in what's called monopolizing practices, and therefore they're entitled to treble of those damages, 3 times the damages. So, in November, this guy, Edmonds is his name, former JPMorgan trader, pled guilty of trading, spoofing the markets from 2009 to 2015. And he was trading in gold, silver, platinum, and palladium, and he pled guilty to conspiring with other precious metals traders at the bank on the COMEX and the NYMEX. And these are CME group entities. And Edmund claims that his bosses knew all about what he was doing. Now remember, he did this for 6 years. And I'll read from what the criminal the press release from the Department of Justice announcing this says, his trading strategy was admittedly intended to inject material false and misleading liquidity and price information into the precious metals futures markets. Now that's what we talk about. He's interfering with price discovery. Natural price discovery would say there's a certain amount of buyers over here, there's a certain amount of sellers over here, based on however they may come up with it. It's not based on supply and demand, it's based on what the traders are doing. So you're already one step removed from the physical markets, but within the paper markets, this guy is messing it up even more, and he is changing the dynamic of what's liquid and what's not liquid and the price information and what people are willing to pay by placing what's called spoof orders in order to deceive other market participants about the existence of supply and demand. And that's the existence of supply and demand of contracts, not of supply and demand of actual physical silver, physical gold, platinum, palladium. And it says that spoof orders were designed to artificially move the price of precious metals futures contracts in a direction, doesn't say which, was favorable to Edmonds and his co-conspirators at the bank, to the detriment of other market participants. So let's say someone has gone short and they've analyzed the market, they see what people are doing, and all of a sudden along comes Mr. Edwards and he's got a huge buy order in that he never intends to execute. A lot of people see that huge buy order. They suspect it's JPMorgan, because who else has that kind of money to put up that kind of bid? And they all go long, and bingo star, down goes the guy who had a short position, because all of a sudden this spoof is out there. So it looks like JPMorgan's going long, and what happens? The order never gets executed. Didn't have to get executed. Why? Everyone else went long, and the market moved, and the short guy lost his shorts. Happens the other way around. Someone's long, looking good, everything's looking good. Along comes this guy Edmonds at JPMorgan, puts in a big sell order. We're not even talking about when you see naked shorts. This is worse than naked shorts. The guy never even makes the order. The guy places the order. And then what he might do is he might execute it, but in most cases, the spoofing is you don't even execute the order. You throw it out there. Everyone sees, like, oh, look at that big short order. It looks like something's going on. We better short, and then, boom, the market starts going the other way. If you were long, you got taken out because the shorts won that portion of the trade. And then he says, in pleading guilty, the Department of Justice press release, Edmonds admitted that he learned this deceptive trading strategy from, where else? More senior traders at the bank. Which means that he picked this up long before 2009, or at least it had been going on there, because how else would he know how to, if he learned it on the job, he must have learned it from people who were doing it before he was. And that he personally deployed this strategy hundreds of times with the knowledge and consent of his immediate supervisors at the bank. So, this is no rogue trader. Sounds like this is what they do. A little spoof in here, a little spoof in there, or at least that's what they did between 2009 and 2015, according to the plea. Now, this says the case is the result of an ongoing investigation by the FBI's New York field office, and so on. And if you believe you have been a victim in any of these cases, you should visit the Victims Fraud Center. You should visit the Fraud Section's Victim Witness website. There's a lot going on there. Victim Witness website for more information. Okay, so that's what happened in November. Now, why are we bringing this up again? Well, these things never end. And just the other day, I think it was December 11th, one of these guys, the people that have this original case going on, and remember, it's a different case, but probably a lot of the trading that happened in this JPMorgan case here, this JPMorgan criminal plea, the facts and circumstances, probably overlapped what happened to the 3 lawsuits in the silver cases, because that happened, they allege, between 2010 and 2011. Well, Edmonds said he was messing with the markets, pled guilty from 2009 to 2015. the three lawsuits are suing JPMorgan for monopolizing and antitrust violations and for fraud and messing with the markets. At the same time, this guy, Edmund, said, yeah, I did it, and I did it with the knowledge of my bank, and I learned it from other senior traders at the bank. So there may be more people that may be subject to criminal prosecution by the DOJ through the FBI investigation, because if I was an FBI agent, I got this guy to plea. He basically said there was other people at the bank, and I learned it, and they knew about it, and I learned it from the trader. So I'm sure when he gets sentenced, let's see, Wednesday, we should be taking a look at what type of plea deal he gets, because it's going to be very important to see what he says. If his plea is reduced, if his deal is, whatever his sentencing is reduced, it's going to be because he says, Mr. JPMorgan told me to do it, and gives evidence about other traders who did it and how much they did it. Now, what does that mean for JPMorgan? Let's look at these other cases. They now break out of the woodwork and they say, whoa, hold on. This guy, what he did, that's what we're saying. So now they're saying, they're all scrambling, because the best thing you can have as a plaintiff's attorney is a criminal conviction or a criminal plea. Why? Because you don't have to go and prove that this stuff happened. That's what they've been trying to prove for, and they might have to amend their plea to piggyback off of this. But once you plead guilty in something, think of the O.J. Simpson trial. He wasn't convicted of being guilty in a criminal trial, but he owed money in a civil case for the wrongful death to the family of the woman he killed. In this case, you have proven the guy's pled guilty to wrongdoing, which means that it's a lot easier to say, well, look, he pled guilty, which is a higher standard of proof in a criminal case. We should be able to get our ducks in a row, and we should be able to show you that, look, the guy did this, and if he caused harm in a criminal case, he certainly caused harm to us. And they'll either go to JPMorgan and say, settle up, which they probably should, because if they go to trial, they're going to have a problem, because they're going to be waving this criminal plea in front of their faces. Now, JPMorgan is going to say, well, this is entirely different. You're talking about antitrust. This is a simple rogue trader. Well, they're going to have a hard time with that argument. So what the plaintiffs, the private suit people have done is, one law firm has come up and he says, look, let's bring all of these actions together, the ones that they threw out the first time but are still going on, the ones that I talked about at the top of the show, the ones that got thrown out then got brought back. They're saying, let's move this together as a class action suit. And this is going to take a while here too, because they're saying, here, we're putting it in there, the court says okay, any opposition to this motion shall be filed by January 2019. Any replies filed by mid-January. Then we're going to have a conference on February 1st. The lawyers are all going to jockey for who's going to be the lead plaintiff. And then we're also going to have more information on the FBI investigation, whether they're just going to nail Edmonds, whatever his name is, the guy who did the spoofing, or whether they're going to open it up on JPMorgan. Now, important to keep in mind here. If JPMorgan is found guilty on a bigger level, what they've been found guilty of is screwing around with the trading on the COMEX. What these three lawsuits are saying are that there could be hundreds of people, maybe even thousands, that were screwed over the years by this messing up of the markets, the manipulation of the markets. But they're not saying that, like, if you went and you bought from Bullion and you lost, that's not a trade. So you're not covered by this. Here's the issue with this case. When people say manipulation, this is the most important part. When people say manipulation, JPMorgan does manipulation, they use that interchangeably with price suppression. What silver holders have been saying and complaining about when they yell manipulation, they're not really saying manipulation. They're saying that JPMorgan, whomever, they're conspiring to keep the price down. In the criminal case and in the civil cases, they are not saying that. They are not alleging that. They are saying that JPMorgan's trading spoofed to try to push people out of positions that could have been going up or going down, going long or going short. So all of this, if it breaks down totally against JPMorgan and more people go down Edmonds turns more people in, and we find out that this is an even bigger and more endemic problem that JPMorgan has had and had for years, maybe even decades, that they were engaged in this, and they're looking at the trading records. They will pay a big fine, and these people will go probably, and you never know, no one ever goes to jail in these things. They plea something out. Chances are, even if it's criminal, there'll be a big fine, and there may even be a big payout to the plaintiff's attorneys in the class action. But let me show you something which is very interessant, as they say in Portuguese, is this chart. I did it a few years ago. It's still relevant. This chart shows that JPMorgan, this is just between 2011 and 2014, paid $35.24 billion in fines. That is a staggering amount of money. $35.24 billion. Global silver mining production in 2015 and pretty much today is worth about $12 to $13 billion. JPMorgan just throws that out there. How much do I owe you for that manipulation thing? Okay, what is that? $3 billion, $8 billion? There you go. Paid that last week too. So that is a very big deal, but JPMorgan can pay it. So what's going to happen next is they're going to argue over this, and chances are JPMorgan will pay a fine. And they'll probably have to issue, this is the most important part, after understanding that this wasn't about price suppression, but this is the part that may help with the elimination of the price suppression, is that they will sign a consent decree and say, we won't spoof anymore. And we'll have internal, if they do it right, and we have internal safeguards to make sure our traders don't do any of that spoofing stuff. However, there's more ways to manipulate than spoofing. Remember the uneconomic bids. It may turn out that in the civil case, the court throws that out. Why? On the business judgment rule. There's a difference between spoofing. Remember, in the spoof, you don't make the bid. There's no reason, there's no business judgment to spoof. The only reason you spoof is to defraud. However, okay, well, we can't spoof anymore. So instead of lining up a big short trade that we're never intending to execute on, we'll just execute the short trade. We'll just do the naked short. And then bam, down you go. And the result there, JPMorgan pays the fine, the criminal penalties for the spoofing, agrees never to spoof again, and probably will get away with spoofing, but doesn't stop them from naked shorting and making uneconomic bids, which might mean then the government gets the fine, and maybe those three plaintiffs that have the class action never see a dime because they can't prove their antitrust case, or they can't prove that the bids were uneconomic and therefore illegal. Because remember, the business judgment rule may help JPMorgan. So it's possible that JPMorgan, and probable, I mean, the one guy's already pled, and we'll see on Wednesday what his plea deal has for sentencing, that JPMorgan will hit again. But as you're looking at this chart here, yeah, they might pay $1 billion fine. So what? They'd have to pay a lot more than that for this to be a big deal for them. Will it impact the way they trade on the markets? Maybe they won't do any spoofing. They've probably already stopped spoofing. But that hasn't, remember, this guy stopped in 2015. So I don't know how it's going to turn out, but I want to give you the facts and analysis as I see it. My guess is that JPMorgan will pay a fine. This Edmonds guy will turn in a few more people. There'll be a bigger investigation. Unless the Department of Justice is serious about breaking up JPMorgan, which I don't see an indication that they are, then the government will win their case, because they generally can always win their cases if they put enough resources against it. But the class action will be able to piggyback off of this, and they may win something, but they may not win their antitrust case, which is where the big money is, and they may be able to amend their complaint to pick up on the damages that were caused by the spoofing versus the damages caused by the uneconomic bids. All right, well, that's what I got. Let's see what you got over here. All right, GSGS says hello. Andrew says, sup, man. He says, where is everyone? We got a big crowd here. They're just they come staggering in on a Sunday night like hobos. All right, Pablo Pena says, hola. Miser says, yazoo. I saw Miser pointed out today, Donald Trump was mentioning or complaining that the only reason this Russian hoax thing has gotten as far as it has is Jeff Sessions allowed it, which reminded both of us of Q, my mom, and QAnon, trust the plan. Remember all that? Oh, Sessions is part of the plan. He's doing nothing, but then he's going to turn around and indict everyone. Well, no, he actually allowed. And that's why I've always had a problem with the that concept, because there is nothing to be gained by having half the country now believe, because they've allowed this to go on so much, that Donald Trump colluded with the Russians, and to have many of his campaign people, Manafort, Flynn, all indicted, to have this damage done. There's no purpose in taking those bullets. There was never any plan to allow there to be a special counsel and to allow Sessions to sit back and allow it to happen. And now he's gone, so he's not part of the plan. And Trump trashed him again today, saying it's all his fault for recusing himself and allowing the special counsel to be appointed. Cue my mom. All right. Show your mugs to scale. Yes. The white one is so small. Andrew, did you get yours yet? I can't keep track. I think just about everyone on this thread here has at least one mug. All right. Litecoin is garbage, says Andrew. Bitcoin bottom is 3K. Trust JPMorgan. I hope you're right, Andrew. Misinformation is necessary. All right, let's see. You guys are chatting. Ann Holloman. I expected her next bubble to be metals. TRP. You guys are talking about Bitcoin. You're talking about, I'm not going to get into that right now. Okay, I want to see if you got any thoughts on the case here. I want to be on the right side of the bubble this time, says Ann Holloman. Yeah, well, one of the things, in retrospect, Yellen and Bernanke both told us, and so did Greenspan. Greenspan said he wanted a housing bubble. So did Krugman. Bernanke and Yellen said the purpose of QE was to boost the stock market and to boost asset prices and to boost real estate. They came out and said, we're going to do everything we can to boost those markets. That should have told everybody, and that made everybody afraid from 2009 to 2011. They said these guys are going to be money printing like mad. We're buying gold and silver. And that worked for 2 years. But they persisted, as they say, and they printed, and they printed. And they finally did QE3, and it was bigger than all of them, and gold and silver went down. And the stock market is still living off of that massive pump and lowering of interest rates and $4 trillion of QE. So if you want to be on the right side of the bubble, you generally, if you believe that central banks are not losing control and that they're firmly in control, you follow what they want, that they're doing. My guess is there's going to be a crypto bubble. I may be wrong, but I think that a lot of money is poured into it, and these companies, Goldman Sachs, Fidelity, Microsoft, New York Stock Exchange, NASDAQ, wouldn't be doing it unless they kind of had a nod that this is what's going to happen. I think they saw the 2017 crypto bubble and they said, we didn't make a cent off of this. This is unfair. All these people on YouTube promoting ICOs, that's our job. We can do a far better job than $40 billion worth of ICOs. We can get that up to $100 billion, $200 billion. They saw those price increases. I think they want a piece of the trading or something. All right. Let's see. Tulips. Okay, Taylor Collins. I was thinking about this today, and I showed this to a few people. Anyone have thoughts on the letters at the Bush funeral? Michelle Obama received a letter at Bush funeral as well. Okay. I don't know. I mean, some people look at that and they think that Jeb Bush was just relieved that the casket had passed. It's very hard to say unless someone is, and I actually haven't seen any good explanations other than either you dismiss it or you can only speculate what's on the paper. But the interesting thing about the reaction is immediate. So it cannot be more than a word or two or three words, and could be a picture. Who knows? But it was very strange to see at that precise point when the casket is going by is when everyone should be solemn and just not passing notes. You should be looking directly at the casket and head down. It was just very strange. I have no idea, and I don't think anybody can come up with anything because it's all speculation, and I guess someone's going to have to, and of course they're never going to ask. Someone has to ask them, what was that all about? Okay. Taylor Collins, I can't wait to have my first morning coffee out of a small gold mug. So I guess you got yours. Then I'm asking for beer steins. Yes, those beer steins. I have mine in front of me here. I have, what am I waiting for? Oh no, they're all here. I have new shipments of, I'm only shipping out the classic and super classic mug from Smaulgld headquarters. All the other products, the beer steins, the frosted mugs, the t-shirts, the hats, all that stuff you can order from the Smaulgld store. All right, let's see. Taylor Con. I'll be having a cold one out of the beer stein in the evening. There you go. Lewis is the man. That's what you, Taylor. Pablo Pena. Taylor Collins. Cue my mug. There's cue my mom. Cue my mug. Said letters stated this date will be counter. Why don't they put in undercover FBI agents to work in these companies? I wonder, I don't think they do, but they could. I know it's interesting, a lot of the, like HSBC, some of the foreign companies, they must have some type of surveillance. RWS Graha 1, JPMorgan going down in flames. I think you're going to get a big fine. I don't think they're going to go down in flames. I mean, their ability to absorb fines is legendary. Look at that. And I only updated to 2014. It's probably over 50 billion now. I don't know if that's going to happen. Miser, burn, baby burn, but not happening. Stock won't even go down from this. Nope. Stock will go down due to financials in general going down. That's probably right. Yep. La Plata Peak. Could the convicted JPM trader's annual performance review, along with the company's emails, be obtained through discovery, be it criminal or civil? Yeah, a smart lawyer would ask for everything, and the lawyers on the other side are gonna try to deny everything. But that's relevant. I would think that his annual performance reviews are probably not going to say, in recognition of all the spoofing you've done and the crimes that you committed, your bonus is going to be X. I mean, his bonus is going to reflect. No, Mike? What are we saying there? Oh, I was worried you guys weren't hearing anything. The bonus is going to reflect the money he made from his trading. But I don't know if that would be evidence in itself that he did illegal trades. Remember, JPMorgan, all these big traders, they generally win on their trades. All right, gold needs to go to 12. You guys are talking the market. I can get into that tonight. The weight hikes. I'm going to stick to this case. All right. The big gold move. Okay. Any Aussies in the house? What's your take on spoofing? Says La Plata Peak. Pablo Pena says JPMorgan will stack mugs to stop the spoofing. We've got a new special surprise coming up. I'll probably have it out tomorrow. So please make sure to tune in every night. But tomorrow I might have a special announcement. If I'm told, oh, I see. There's something, yeah, it's probably in the word spoofing. Wow, nice chart, Lewis. Yeah, that was a real intricate chart there. JPMorgan fines $35 billion. EB SX. How'd you pick that one? That name. Isn't spoofing the whole basis of the high frequency trading industry? Didn't think it was illegal. No, spoofing is illegal because you're putting up a trade that you have no intention of making. I mean, it's worse than naked shorting. Naked shorting, you at least have some liability. And I just stroll into the market and say, I'm going to sell. Let me just line up a trade here for $400 million. It's going to move the market. It doesn't, unless you're actually going to push the trade through. Now, it does get tricky because oftentimes people can change their mind. You say, I think I want to make this trade. I want to make this trade. Nah, I don't want to make it. So, and then you realize, oh, look what I just did. I just moved the market. And then you do it again, even if you did it by mistake in the first place. All right. Roger Henley. A rate hike will cause a crash in the mug markets. That's true. Good news for mug hoarders. Load the truck with cheap mugs. Yep. I mean, in fact, you need to diversify. You need to get the beer mug. You need to get the espresso mug. You need to get the travel mug, the classic mug, the super classic mug. Very important. Very, very important. All right. La Plata Peak. SNL should be illegal. Paying hush money is totally normal, and having to take out Craigslist ads to fill a White House chief of staff role is just how things are in the 21st century. Plan on getting into Bitcoin. We're not covering that tonight. All the miners, Bitcoin. That is true. You know, you have to wonder. No miners, no system. That is true. That's the one thing that could knock the whole thing off. All right. Fine equals cost of doing business, mate. That is correct. That is clearly correct. It's a cost of doing business, and I would say when they pay fines to the government, it's a related party expense because they're both in it. The government seems to like using JPMorgan as a revenue source. What, $35 billion there? Yes, until the fines are 10 times the profit on the trading and all participants in jail, the business as usual. Exactly. Because if all you're going to do is pay a fine and you're going to make $10 billion and you pay $600 million on a $10 billion profit, get the checkbook out. That's fine with me, right? As long as you don't go to jail. And unbelievable. All right. Let's see what else we got here. All right. That's about it. Well, I want to thank everyone, all the Smaulgld mug buyers and game changers out there for joining me tonight. And we will see you tomorrow. And I hope to have a announcement. Change is a coming. See you tomorrow. I'll leave you with a good night. And I'll leave you with the Smaulgld website. You go there. That's where you can get. That's where the good stuff is. That's smaulgld.com. You can sign up to be a patron. You can get a mug or 2 or 3. You can buy coffee there. You can buy gold and silver through the affiliate links. It is a spectacular website, smaulgld.com. Get on up and get on over. Good night, Ann, and good night to all.